Hello friends, I welcome you all in one more knowledgeable, interesting video. Today in this video, we will going to talk about a recent judgment of Honorable Supreme Court of India in the case of State Bank of India. A major setback for State Bank of India in this case, and this case is about allowance of LTA, Leave Travel Allowance or Leave Travel Concession. There were few disputes between the department and State Bank of India, and the matter got escalated to Honorable Supreme Court of India, and Supreme Court of India recently announced its judgment on this matter. Let me first explain you what actually Leave Travel Allowance or Leave Travel Concession is. Leave Travel Allowance is allowance given by the employer to its employees for traveling expenses for two journeys or two travels in the block of 4 years. The block is a block which is to be created of 4 years by the income tax department, right? And then employee, after traveling, employee have to submit the bills, claims, hotel bills, airfare or train fare bills. So employee have to submit these bills to the employer, and then employer will give exemption from the deduction of TDS to the employee. So in this case, employer that is State Bank of India had not deducted TDS, right? And majority of the employees had traveled in a foreign country. So that was the dispute, and it was a just about what LTA or what LTC is, right? Now SBI allowed LTC to its employees who traveled to the foreign country, but when we look at the section 10 clause 5, it is written there that the journey or the travel has to be in India. So what the employees were doing is that they started their journey from a point which is located in India. They go to a place which is located in India and they travel to foreign country. Then they come back to a place which is in India, right? So that was the justification that State Bank of India submitted in this in support of its argument, and Honorable Supreme Court of India had clearly in this judgment reject this submission of State Bank of India that LTCA claim exemption is to be allowed only when the travel is in India. If the travel is in a foreign country, then exemption is not allowable. So SBI has to deduct TDS, right? So department contention was that SBI fails to deduct TDS for foreign traveling allowance. So department held State Bank of India as assessee in default. So the point is that very important point held by Honorable Supreme Court in this judgment is that the LT exemption under section 10 subsection 5 is not allowable if the travel is in a foreign country. Yes, so the next important derivation that we got out of this Supreme Court judgment is that when the travel is not in India or when the travel is in a foreign country, then the employer have to deduct TDS under section 192 because it is a part of a taxable salary, because you are giving allowances or concession to the employees for traveling. But if employee travel to the foreign country, then there is a breach of condition as mentioned in section 10 clause 5. So it becomes a part of taxable salary. So if a component becomes part of the taxable salary, then TDS deduction is compulsory, right? So it is a part of taxable salary of that employee. So employer have to deduct the TDS. This is a very important derivation that we got from this Honorable Supreme Court of India judgment, right? So one more important point, one more important insight that we got from this Honorable Supreme Court of India judgment is that LTC claim or LTC expenses includes various expenses like your food, your stay, your travel, and your cab, your taxi, everything. So that all the expenses has to be incurred within the boundaries of India, right? If any of the expense that is incurred outside the boundaries of India are not eligible for exemption under section 10. This is also one of the most important point that we derive from this Honorable Supreme Court of India judgment, right? So airfare, one more important point is that airfare between the 2 points within the India has to be given, and which route we need to select, that is the, like, few of the employees claims LTC that they took flight from Mumbai to Chennai, and they go to Mauritius, then they come back to Chennai, and they come back to Mumbai, right? So this should not be the case, right? LTA is not allowable now from the Supreme Court judgment orders date on this type of journey, right? That journey has to be in India, and the route has to be the shortest possible route. Airfare has to be allowed. If it is not the shortest possible route, then the route which is in excess of the shortest possible route is a part of taxable salary component, right? So this is one of the very important insight that we got from this Honorable Supreme Court of India judgment. So a very, very important judgment and a big setback to State Bank of India as assessee in this case. And Supreme Court very well mentioned in its order that how assessee like State Bank of India did this error, did this mistake of not deducting TDS from LTC of employees who travel to foreign countries. This is like elephant is there in the room, right? And SBI is ignoring it. So a very important judgment on LTC or LTA. So it was all about this judgment. If you have any query relating to this judgment, you can post your query in comment box, or if you have any query relating to any of the provisions of Income Tax Act, you can ask that query by posting a query in the comment box. If you wish to have the complete copy of the judgment of this Supreme Court of India, then please comment your mail ID in the comment box. Please subscribe to the channel and like this video. Thanks a lot. Bye.